Thanks everyone for joining us today. We are with the Boyden Gray Center for this study of the administrative state in our podcast series called Pulse of the Court. It's been several months since we have recorded an episode, but now we've got some late breaking decisions here at the end of the term. And I have two great and emerging scholars here to talk with us about the court's decision yesterday, June 30th in West Virginia versus EPA, one of the final two decisions handed down in what really was a blockbuster term, seeing the court handle issues such as guns, abortion, overruling Roe versus Wade, and some very significant administrative law decisions. And so I have two individuals who write in the areas of administrative law and actually more broadly constitutional interpretation scholarship, and will tell us a little bit more about some of their work later this episode. But they've also written specifically about questions of delegation, meaning are there or should there be any limits on how much power Congress delegates to administrative agencies, since Congress has been given by the Constitution vested with all legislative power? Does that requirement, does that authority given exclusively to Congress in any way impact the kind of authority that Congress can then in turn assign to agencies? Or if Congress too broadly legislates, would that be delegating its power too much to agencies to be policymakers instead? That question then leads to some other issues that were more before the court in the West Virginia versus EPA decision. Once Congress has handed over power, how will the courts and agencies look at the scope of an agency's authority under a congressional statute? Does an agency need to be really careful to narrowly read its authority? Should the agency read its authority as broadly as possible? Is there a way with some of these general vague statutes for the agency to just get it just right and interpret its authority within the range of the statute? So the court yesterday in West Virginia versus EPA essentially found unlawful a very significant regulation promulgated by the Obama administration in 2015 known as the Clean Power Plan that was going to deal with carbon emissions, and essentially found that the Obama EPA exceeded its authority under the Clean Air Act, a little provision called Section 111D that essentially was going to authorize or does authorize the EPA to come up with performance standards for existing power plants. And in a nutshell, the court found that EPA in the 2015 rule improperly used a provision that was really just supposed to authorize it to impose a performance standard, keeping in place existing sources, and instead use that to more broadly create rules that would actually shift power generation from coal-based plants and even natural gas-based plants to more renewable sources. And the court said that that was too extensive of an authority to find within that statute, that the statutory provision at issue didn't allow shifting sources, shutting things down for all intents and purposes, but just trying to make existing sources a little bit cleaner. So we're going to talk about the impact of that decision today. We're going to talk about a pesky but very fascinating for ad law folks doctrine called the Major Questions Doctrine. What does that mean? What does the court's imposition of the Major Questions Doctrine and the decision yesterday mean for regulations even beyond the EPA? And did the court yesterday, in fact, do something new, or has the Major Questions Doctrine been with us all along? More, Justice Kagan raises a criticism, a significant criticism, an attack really in her dissent, saying that the majority is actually not textualist in any way, and that the Major Questions Doctrine actually goes away from the constitutional instruction to interpret statutes as they've been passed by Congress. So we're going to talk about whether that is indeed correct. So first, let me introduce our guests, and then we'll turn things over to them. So we have Chad Squitieri, who has been practicing law with Gibson, Dunn, and will be joining Catholic University as an assistant professor of law in the fall. And specifically, he is also going to be working with the Project on Constitutional Originalism and the Catholic Intellectual Tradition. He has written pieces that have been published in the Missouri Law Review, among other publications, and written on delegation and interpretation. And so we're excited to have him with us today. And then we have Nachmany, who is recently graduated magna from Harvard Law School, will be clerking for Judge Steve Menashe on the Second Circuit. And he's keeping busy this summer, also working as a senior research fellow at the Gray Center and then writing a Sports Illustrated column. He is also publishing scholarship and had a brief article on the Northwest Ordinance from the 1700s and the delegation doctrine published online recently. And so would love to hear from both Chad and Ellie on their pieces and also on their view of the constitutional and statutory impact of yesterday's decision. So Ellie, why don't I first turn to you? In a nutshell, what did the Supreme Court hold yesterday? Why did they even reach out to find the 2015 Clean Power Plan unlawful?
Yeah, so a little bit of background I think is important here. This proceeded really, I think, in three parts. So first is you had the Obama administration in 2015. Its EPA attempts to impose the Clean Power Plan. That eventually got up to the Supreme Court. The Supreme Court stopped the Clean Power Plan from going into effect. Obviously, there's the election in 2016. The Trump administration comes in with a different regulatory philosophy at its EPA. It then says, we don't have the statutory authority to impose the Clean Power Plan, so it stops it. And then the Biden administration comes in, and it's not clear exactly what the Biden administration wanted to do, but I think their first priority was, let's get this case out of the Supreme Court so we don't get a ruling like this. So the Biden administration says, well, hold on, we're now thinking through what exactly we're going to impose in terms of environmental regulation under this or other provisions of the Clean Air Act, not necessary to rule on it. The court rejects that argument, says we can rule on this because what's going on here is what's called a voluntary cessation of conduct. Essentially, that the only reason that the case is moot or the case shouldn't be heard is because of the Biden administration's voluntary conduct, saying we're not going to do this regulation, or at least right now we're not interested in imposing this regulation. So the court goes ahead and reaches the merits of the case, reaches the actual statutory question here, which is, does Section 111D, this ancillary provision of the Clean Air Act, really what Chief Justice Roberts called a gap filler in the statute, authorize a sweeping national implications plan like the Clean Power Plan? And the Supreme Court said no, that simply authorizing the federal agency, in this case the EPA, to set a best system of emission reduction at individual sources is not sufficient to confer the authority to make a wide-ranging plan like the Clean Power Plan. And so the court said to the EPA, you don't have the statutory authority to do this. The court rested its holding on the major questions doctrine, which I think we'll discuss more in general. But this was, we talked about non-delegation. This was a statutory interpretation case, not so much a non-delegation case, though delegation certainly lurking in the background of this and a lot of the other agency interpretation cases.
Well, thanks, Ellie. So, Chad, what are we missing here? Do you agree that it was proper and teed up for the court to rule yesterday? And any particular big takeaways from the decision that you'd like to add?
Yeah, I think the court was right to rule in the decision. I think one of the takeaways from the decision will be the initial part of the majority opinion, talking about the difference between standing and mootness, and essentially the state petitioners here were injured given the repeal of the Trump rule, which implicitly incorporated the appeal of the Obama rule. So I think state petitioners were injured by essentially that Obama EPA rule being back into effect, which required them to regulate energy companies more aggressively. As Ellie mentioned, I think this is going to have wide-reaching effects throughout the administrative state, more outside just environmental policy as well. And I think I've written a piece about how I think that the major questions doctrine is inconsistent with textualism. I'd be happy to talk about that as well. I think Justice Kagan might have hit a good point in her dissent.
All right. Well, I want to turn to you in a few minutes to talk about your piece. First, I guess I'd like to ask, and I'm happy for either of you to weigh in if you have thoughts. So you all both seem to agree that it was proper for the court to rule yesterday. As a practical matter, however, the Biden administration has moved on and does not, at least according to what it said, wasn't going to be reissuing the 2015 Clean Power Plan anyway. Instead, it was working on a new regulation. So what kind of impact then in a concrete way will this particular holding have on the Biden administration? Is it going to just, other than just some general principles? Is it going to not be that relevant because the Biden administration is working on a new regulation? Or do you anticipate this ruling is going to tie the Biden administration's hands? What's off the table now for the Biden administration after the holding yesterday in West Virginia versus EPA?
But I think the initial Obama EPA rule is off the table to the extent that the Biden administration was thinking to go back to that. I think the concrete result here might be what Justice Gorsuch and the majority were getting at, that is going to essentially shift decision-making authority back from the agency over to Congress. My understanding of both the majority and Justice Gorsuch's concurrence is that the EPA, if they wanted to implement the Obama era rule, they could, but we're going to need to see new language from Congress. So rather than having a policy centered at the EPA, perhaps there'll be a political tension at Congress. Congress could pass a new statute and give the EPA that authority.
Yeah, so I mean, basically, if the Obama administration or the Biden administration had not been, being entirely forthright or had planned to put out to revisit some parts of the 2015 Clean Power Plan, it can't do anything that was ruled on by the court yesterday. But I mean, how is the Biden administration going to evaluate things moving forward? The statute says that the EPA has the authority to impose a performance standard. The majority of the court suggested that it was going too far if the standard was actually designed to shift power from one source to another. So if it was going to actually reach the performance standard by shutting certain parts of industry down entirely, like certain categories of plants. So does the Biden administration, what does it do now? Does it just have a less significant performance standard? Is it going to be writing its new rule to just explain how it's not going to be shutting down coal-powered plants? I mean, is it a problem if any plant can't reach the standard that the EPA established? Does that mean that it's gone too far?
So that might be true, that last point. If an individual source is not able to meet the standard, that seems like it could be an issue under at least the way that I read the majority's opinion. I think the main distinction here is between the ability of the EPA to impose regulations that impact individual sources and consciously operates as a regulation of individual sources one by one, versus a sort of collective power plan that attempts to reorient the way in which the national power grid works. So instead of thinking, we want to broadly shift from coal to natural gas and then coal and natural gas to more renewable sources, what I think EPA needs to do here, if it wants to regulate under, again, what is really an ancillary provision, and I think the nature of its ancillariness probably sets some boundaries for what the reasonableness of the standard that it can impose is. But EPA is going to need to work with the states. It's probably going to need to work with industry to set forth a more reasonable regulation and something that's not as sweeping or as far-reaching an authority claim as the Clean Power Plan purported to be.
So we've talked already in this podcast a couple of times about something that we're calling the major questions doctrine. Chad, could you just tell us briefly in a nutshell what that doctrine is, or at least how the court described it in the decision yesterday?
Sure. So the major question doctrine has been kicking around at least for a couple decades, although Justice Gorsuch traces it back to the 1800s, I believe. But it really came into its own, and this opinion yesterday was actually the first time that the majority explicitly used that term. The major question doctrine essentially asks if a question that's being answered by an administrative agency, if it is of vast political and economic significance, then the court is going to look a little more skeptically at the claim that power has been delegated, and it's going to require a lot more clear language from Congress delegating that authority to the administrative agency to answer that question of vast economic and political importance.
So Ellie, anything to add on the contours of the doctrine as the court states yesterday?
Yeah, so I think we ordinarily thought of it as just about the questions of national, economic, or political significance, but it seems that the court adds this idea of the broadness and the novelness of the agency's claimed authority. So now what we might also look to is, has the agency claimed this authority in the past? Is it consistent with the agency's claims of authority under a given statute? And ordinarily, you have, as one article has described it, an old statutes, new problems issue, wherein agencies look to these statutes from many, many years ago and say, we have this new authority to promulgate new regulation under a statute from the 60s or the 70s that it may fairly not have contemplated that sort of regulation. And so if the agency is now for the first time claiming that authority, and that authority is pretty broad, or, and the court even introduces, if the agency has gone to Congress and asked for the authority more explicitly and Congress has said no, that stuff all might factor in. And so the major questions inquiry seems to be, if not just clarified, it may be even a little more extensive than we thought it was.
I mean, what you're suggesting, I find quite interesting, right? Because, I mean, presumably administrative agencies are in place to be developing ongoing solutions and regulating, and they've got the statute. And so, I mean, is it really the case, and is the court saying now that essentially any new use of authority adapted to new problems is going to be off the table? Is that too constraining? Justice Kagan begins her dissent by talking about the big problems with greenhouse gas emissions and how the environment is really struggling. And essentially this opinion is going to make it very challenging to rule. So Chad, are we without hope? If you're somebody who likes the government stepping in to address climate change, is that now completely off the table after yesterday's ruling?
I don't think that it's off the table or without hope. It's really just a matter of, to the extent that this is an agency puts forward a brand new idea for a decades-old statute, the court is going to pause and think a little more skeptically about that claim. It doesn't mean that every time an agency has a new unique idea, it's always going to be seen as skeptical. But in instances like this, the court has indicated that it is going to view that a lot more skeptically. I think just a small point about the methodology. I do think the initial step for the major questions doctrine is still to say this is politically or economically significant. And then as Justice Gorsuch lays out in his concurrence, the oldness of the statute really comes in the second section when the court is looking, has there been a clear command from Congress delegating this? And one of the factors that the court will look to determine if there's that clear statutory language is the age of the statute and statutory scheme and other things of that nature.
Right. Okay. So essentially, at the end of the day, the question comes down, and I think this is for sure a theme that comes out in Justice Gorsuch's concurrence, but I think also the Chief's majority opinion to a degree. Who decides? I mean, climate change can be addressed. Congress really would have to initially give the agency the authority to address it. And it sounds like what we're saying and what the court's opinion was holding is that if we've got statutory provisions, in this case, I believe one that was originally from 1990, the rest of the Clean Air Act, parts of it are older even than that, that the statute really has to be clear about authorizing the action, or at least directly authorize it. It can't be sort of a stretch or something that we're kind of guessing might be okay based on general purposes or goals. So when Justice Kagan writes in dissent, well, generally speaking, the Clean Air Act, actually, I don't want to mischaracterize it. She doesn't say generally speaking, but she says the Clean Air Act addresses and authorizes and actually instructs the EPA to regulate the environment and to regulate the air and make it clean. And so this regulation was, the best means oriented to reach that goal. I guess the majority and the concurrence would say, well, that's not enough. It's not enough to generally fit within the terms of this old statute. We've got to see clearer language. Do you all think, based on the court's ruling yesterday, that the age of the statute is a critical component? If Congress just last year in 2021 had enacted the same provision, with us all being aware of clean air, greenhouse gas debates, do we think the court's decision would have come down differently here, or would it still have found that the EPA was acting beyond its textual authority?
So I think it's related to a second point in the major questions doctrine, which is, has the agency claimed this authority before? So if the statute has been around, let's say since, let's say 1980, and in 1981, the agency made this claim of authority or an analogous seeming claim of authority, and it had been going on for 40 years and had been making that claim of authority, the age of the statute probably wouldn't matter. But the age of the statute might matter if it's passed 40, 50 years ago. And in that intervening period of time, the agency hasn't made such a claim. So we look to, the court characterizes it the novelty of the claim. And so the age of the statute may function as a way for that lack of claimed authority to accrue. But I think the age of the statute itself, so long as accompanied with agency action or claim of authority or claim of right near the inception of the statute, may actually function as being fine. My downstream question now is, does this decision encourage agencies to, as soon as a statute comes down, immediately claim all authorities under the statute so as not to lose them as time goes on, if we're going to start evaluating agency claims of right? And then another thing is, if we're evaluating, has the agency gone to Congress to ask for explicit statutory authority, even when it might already be on the books? Is that going to discourage or change the way that the president interacts with the legislature in terms of asking for authorities that the president might want to plausibly claim he already has?
Yeah, I think
Thank you for that. Oh, go ahead.
So I was going to say quickly, I think the last point Ellie raised about agencies having incentive to aggressively use their authority pretty quickly is absolutely correct. And even more in the weeds, I think perhaps in future rulemakings and preambles, we might see agencies claiming, oh, we have very broad authority, but in this rule, we're only doing this narrow thing, just laying that ground point for the future.
So, Chad, are you a textualist?
I am a textualist and an originalist, yes.
Okay, so Chad is a textualist and originalist, and earlier said something shocking that Justice Kagan's here opinion might be right, and the Chief and Justice Gorsuch, who would have been thought to be more textualist, might be wrong. And indeed, the Chief's opinion was joined, including with the Chief, 6 justices, including individuals such as Justice Barrett, Justice Kavanaugh, Justice Thomas, who of course is quite a prominent originalist and textualist and believes in quite, to a quite significant degree, holding the federal government's feet to the fire to be acting only within its Commerce Clause authority. So Chad, how can it possibly be that a textualist would find themselves aligned more with Justice Kagan in this case than with the other 6 justices who were in the majority? Can you unpack that for us a little bit?
Yeah, happy to do so. I'm in the somewhat awkward spot of thinking that the majority might have been correct in the judgment, but I think they took the wrong way to get there. And I think the major questions doctrine is inconsistent with textualism.
So tell us a little bit about that.
Yeah, so I for those interested, I wrote an article expressing this a little more in detail called "Who Determines Majorness?" It was published in the Harvard Journal of Law and Public Policy. And there I essentially argue that the major question doctrine is inconsistent with textualism for 2 reasons. And it calls on courts to engage in an ordinarily futile task, and it's a statutorily suspect task. So the ordinarily futile part is textualists believe that, the 536 members involved in legislative process, Congress and the president, they all have different understandings of what might be important in a statute, and all those understandings come together for the reasons that Justice Gorsuch wrote in his concurrence. It's important to have this dispersed view of our elected lawmakers making laws. They agree on a settled statutory language. The major questions doctrine comes in that says the court saying we as the court are inserting ourselves into this Article 1, Section 7 lawmaking process. We as the court think that this specific issue is of important political significance, so we are going to demand a special statutory language. So I think that's inconsistent with textualist ideas of how the legislative process works. And I also said I think it's statutorily suspect. There I point to the Congressional Review Act. So the Congressional Review Act says that it's a statute by Congress that says agencies, when they answer major questions through, quote, major rules, that's a defined term in the statute, those major rules are to be given effect unless Congress affirmatively enacts a new law saying, no, this major rule shall not go into effect. And the CRA's definition of major rule tracks on to very closely to the court's doctrine of major questions doctrine, in that it considers political significance and economic significance. And importantly, the CRA defines federal agency to essentially cover every single federal agency. So within the CRA, we have a congressional presumption saying, we as Congress are envisioning that essentially every federal agency is going to be answering major questions through major rules. And those major rules are to be given legal effect unless we say as Congress differently. And I think the major questions doctrine just turns that up on its head. And I'll just add one more point that I think that the major questions doctrine creates perverse incentives for litigants, particularly at the lower courts. And I would just query whether those incentives are consistent with textualism, because now we have a situation where right off the bat, a litigant's going to go to court and say, Your Honor, here's some legislative history from Senator A, Senator B, showing that this issue before you is really politically significant. And the opposing counsel will say, we have legislative history from Senator C and D showing that it's not politically significant. And just query whether that type of inquiry is consistent with a textualist enterprise as compared to maybe the methodology that Justice Thomas just laid out last week in Bruin, which is more focused on textual history.
Okay, so it is the case for sure that the court repeatedly refers to the major questions doctrine being really limited to questions of national economic and political importance. And so I take your point that now, one of the arguments in litigation, and presumably one of the arguments the agency may or may not want to talk about when it promulgates a rule and explains what it's doing and why it's not a major question, will have to do with whether it has national economic and political significance. But did the court yesterday clearly suggest that it was going to be willing to turn to legislative history to look at that? Is that just one possibility? Is that a realistic possibility? What is the other evidence the court would look at?
I think it's realistic. I was kind of shocked in the majority opinion. The chief cites legislative history when he talks about this provision of statute being a backwater or something like that. Just looking forward, I imagine, that things like citations like that might be even more common, which I just think undermines the textualist methodology. I think the better course of action would, because certainly the major questions doctrine, as I've written before, is scratching the non-delegation itch, right? It's motivated by non-delegation. And the major questions doctrine is kind of seen as this halfway point. I think a more appropriate method would be to continue going forward with the reinvigoration of the non-delegation doctrine, not this kind of halfway point that considers political importance, which I think is just not relevant.
So I want to pause here on legislative history for some of our listeners who may not be as up to speed on the long decades of views that textualists have formed or the courts have formed on legislative history. So from a textualist standpoint, and Ellie, maybe I'll turn to you. And then Chad, you can tell us anywhere that we're wrong. Is legislative history off the table for a textualist? Is there ever any appropriate way to incorporate it into one statutory interpretation? If one were going to do the full Scalia approach, since he was known as being a key incubator or proponent of the textualist methodology.
Yeah, so Justice Scalia said, basically never will you use legislative history in the interpretation of a statute. It elevates above the view of the Congress generally, the views of individual specific legislators who might have just been a little louder during the legislative process. And what really we're trying to do here is, as Justice Barrett has described it, is be faithful agents of Congress. So I think when we're doing textualism generally, what we're trying to give effect to is the grant of the judicial power of the United States in Article 3 as it was understood at the time of the framing. And so when you have something like the major questions doctrine, effectively the doctrine is functioning as a canon of statutory interpretation, or a way that we filter our interpretation of statutes. There's two types of canons, right? There's the semantic or linguistic canons, which are just rules, pertaining to grammar or how Congress might write something. If a comma's here versus there, if there's items in a list, we might interpret other items in the list if we like it. And then you have what are called the substantive canons. There's something called the rule of lenity, which is we typically construe criminal laws in favor of defendants. There's something called the Indian canon, which actually used to be a rule of treaty interpretation between the United States and the Indian tribes, where we'd rule if there was ambiguity, we'd resolve it in favor of the tribe. That developed into a canon of statutory interpretation. And now you have the major questions doctrine, which Justice Gorsuch's concurrence at least traces, I don't know if it was the major question doctrine, but at least traces something like a clear statement rule back to 1897. My thought would be that if a canon is going to be legitimate, what you might want to do is see, was it a canon that was understood at the time of the framing, the time of Article 3's adoption, to be encompassed within the meaning of the judicial power of the United States? And so, you would have the semantic canons, right, that are just sort of linguistics and how you do language. Those probably all get in. And then as to the substantive canons, the ones that really have some sort of substantive impact on our statutory interpretation, you might look to the ones that had their history or tradition in the Anglo-American common law that would have been understood to law interpreters at the time of the founding. The lenity gets in. The major questions doctrine, I'm not as sure about. It seems to me to be more a political theory assumption. Maybe it's right? Maybe Congress, when it legislates, wants to be clear if it's going to grant major authority to agencies. But I don't know that the major questions doctrine necessarily has its roots in the English common law to the extent that we would go back to the founding and say, yes, when the framers, ratified the Constitution, including Article 3, it would have been included within what the meaning of the judicial power of the United States was.
If I could add one.
Chad, do you agree that legislative history is always inappropriate for statutory interpretation?
I don't think it's necessarily always inappropriate. I think it's best explained. Justice Scalia said something along the lines of, legislative history is about as relevant as a New York Times article about the topic. It helps us understand what the words might mean when individuals are talking about a piece of legislation, but whether that's in the legislative history, the New York Times, or a law review article, these are all clues. I think that the key point with legislative history is not to elevate it over the text of the statute. Justice Barrett, as a law professor, had a great article about this, I think, called Congressional Insiders and Outsiders, something like that. I'd add that Ellie's point about identifying the canons at the time of ratification, I think is exactly right. An interesting point about Justice Gorsuch's concurrence is, he cites a lot of then Professor Barrett, who did a lot of great work on this. And her work is specifically tracing the canons through history, the substantive and linguistic canons. But we don't see Justice Barrett signing on to the Justice Gorsuch's concurrence. And that could be for any number of reasons, who knows why. But I thought that's interesting. And I'll just add that, yes, I happen to have a disagreement here with the majority and Justice Gorsuch in this logical issue. But I think that is the importance of what legal scholars can do. We can help think through doctrinal changes a bit more than courts have the fortune of doing. Courts are restricted. Federal courts are restricted to answering, the cases and controversies before then. They don't have the privilege of kind of like pontificating about broader issues. So I know that many justices, or the justices, the majority and concurrence, are committed textualists, and I hope that they'll continue to think through this and perhaps pivot from the major questions doctrine back to a focus on the non-delegation doctrine.
I mean, is there any? And we'll explain to us actually while we're here and pausing for a moment what the non-delegation doctrine is that you're referencing.
Yeah, so the non-delegation doctrine essentially polices Congress's ability to delegate its powers to other entities. And specifically, we're talking about administrative agencies. Currently, the test is to ask whether Congress has given the administrative agencies a quote, intelligible principle. That test has only been applied to strike down statutes twice, both in 1935. I have a theory about the non-delegation doctrine as well. I actually argue in favor of creating multiple doctrines assigning to each of the legislative powers that Congress is afforded in the Constitution. Because if we look at the vesting clauses, we see Article 2 talks to the executive power singular. Article 3 refers to the judicial power singular. Article 1 refers to all legislative powers, plural, herein granted. And we also have other powers granted in Congress and other parts of the Constitution, including Article 4, which Ellie has written a great law review piece about. So I think each of those powers uses different words. They were enacted at different times. We look at the powers in the amendments. So I think the non-delegation inquiry should change depending on what power is being spoken about.
Great. So Ellie, I want to give you a chance, since Chad mentioned your work, to talk a little bit about your scholarship in the area. And then I want to return to the major questions doctrine and whether it can be reconciled with textualism.
Absolutely. So this all dates back to Julian Mortensen and Nicholas Bagley, two professors at the University of Michigan, published what I really thought was a groundbreaking article in the Columbia Law Review saying the non-delegation doctrine is not originalist. And as part of their argument, they marshaled support from examples of what they called delegations at the founding, which were statutes that Congress passed that purported to delegate legislative power in some form or fashion to the executive branch, or in the case of the Northwest Ordinance, which was passed in 1787 and ratified by the first Congress in 1789, purported to grant a significant tranche of legislative authority, including the authority to make criminal law, to the governor of the Northwest Territory. Pursuant to the Northwest Ordinance, Congress was regulating, and in effect, it was delegating legislative power at the founding. So, what do we do with this, right? Does this establish that there was no non-delegation doctrine at the founding? And here's why I said no. And so I pushed back on the Mortensen-Bagley example and said, this piece has a limited scope. It's going after one of the few examples that they brought about. But essentially what was going on in the Northwest Ordinance is that Congress was not legislating pursuant to its Article 1 powers. And so Article 1's vesting clause, all legislative powers herein granted shall be vested in a Congress of the United States, is typically seen as the source of the non-delegation doctrine. What was happening in the Northwest Ordinance was that Congress was regulating pursuant to its Article 4 power under what's called the property clause, which is that Congress shall have power to make all needful rules and regulations respecting the territory or the property of the United States. And given that the Northwest Territory at that time was a territory, Congress was merely regulating pursuant to a different power that, if it is touched by the non-delegation doctrine, right, if there is a non-delegation doctrine in the property clause, it either is different than that of Article 1 or there's more historical work to be done. But my basic thesis is this Northwest Ordinance shouldn't be taken to cast aspersions on the existence of a delegation or non-delegation doctrine within the vesting clause of Article 1. I should also note Ilan Werman had a good point on this as well. And Professor Squitieri, I know you've mentioned this as well in some pieces that you've written, is that the delegation was also not to the executive branch, it was to a local government. And so instead of just the Article 4 issue, you also might say that the upshot of the non-delegation doctrine is we're concerned about Congress delegating to co-equal branches of government, the judicial, but in most cases we deal with today, the executive branch.
Yes, and also, obviously the legislative vesting clause is directed toward exercises of federal power and federal policy. And so to the extent that something other than legislating as a federal matter is at issue, then perhaps that is a relevant distinction. And I'm glad that you gave a shout out to Ilan Werman, who has, as you mentioned, has written on delegation, taking a different view, of course, from Professors Mortensen and Bagley, and then Gary Lawson's also done work. And then in the GW Law Review several years back, I had a piece that just simply points out that perhaps in tension with some of the arguments, which are right, that there are some statutes enacted by the first Congress that seem to be quite broad. They may or may not be actually engaged in delegating legislative authority. They might be doing something else. But that one thing that gets overlooked is the customs laws and how detailed they were, and then all of the debates and thoughts about the initial members of Congress about why they were so concerned about those policies. And, of course, the fact that legislation was done with specificity does not in any way prove that the legislators engaged in the specificity in the legislation thought it was constitutionally required. But there are some interesting discussions, and you can see the geographic and regional interests that are at play with the customs laws, which might suggest a constitutional structural reason that we should consider delegation limitations to be embedded in the Constitution. Not only that if we think legislative power is imposing new policy burdens and therefore it was given completely to Congress, but why do we have the legislative structure and the electoral structure structure that we have in the first place, with representatives from different districts and states throughout the country, different senators representing states, because the states and local areas, there might be different solutions that are better in one place than another. And so part of what was going to make federal legislation tough to reach a majority vote on is that all of these individuals representing varied geographic interests and regional interests were going to be having to come together. And only if there could be a majority agreement on a solution that could be fine nationally, keeping in mind all of those very conflicting interests, at least in the custom space, would there be law. And so you get a very different flavor of electoral representation when you've got Congress acting divided between its two houses than you get when you have an administrative agency that's headed by an official that's not been elected at all. And even as Justice Kagan points out, which is correct, even when the agency official is directly accountable to the president through the president's ability to direct that person or fire them. The president, of course, is elected, but again, that's one individual representing a national body. And so it's just a different, again, flavor and kind of interest than needing to get majority support from people who are actually in a more direct, granular way representing the interest of states across the country. All right, so we are coming to the end of our time here, and perhaps both of you will resist the question, but I mean, the majority opinion, and I take it Justice Gorsuch writing his concurrence, seem to believe that, or at least are not bothered by Justice Kagan's accusations that they're not textualists, and seem to think that what they're doing is actually the legitimate constitutional mode of interpretation. So while the major questions doctrine definitely has language at times where the court is saying, well, we're applying this in extraordinary circumstances or to issues of national political significance, maybe it'd be more textual if they applied the doctrine to all legislation. But is it not just most simply the court saying, when we have really big issues at stake, we're going to be extra careful to make sure that what the agency is doing is within the four corners of the statute? The court actually does not go so far as to do what we sometimes think are required in clear statement rules. And I think this is sort of an important distinction. Often clear statement rules are thought to mean that a statute has to actually explicitly authorize or reach the conclusion that the litigants are arguing for, almost like an express statement rule. And if that were the case, it would basically mean that here the EPA could not promulgate a regulation that would shut down a coal-powered plant unless the statute actually said, and you have authority to impose standards that would close down a coal-powered plant, which of course seems like a sort of mind-numbingly ridiculous level of detail to expect Congress to put in a statute. Perhaps, maybe some would disagree. The court doesn't suggest that it has to be that specific. It says clear statement, but it seems to almost be suggesting that you just ordinarily need to be able to understand the text that way. You can't parse something new and novel and big that's attenuated from this outdated text. So if the court were to apply that interpretive principle to everything and weren't to suggest that we're just a thumb on the scale for outdated statutes or big issues, would it be just simply consistent with statutory interpretation, the requirement that we make Congress impose the policies rather than agencies?
I think that distinction is precisely the one I take issue with. I think if the court were, extra careful with all statutes, I think that would be consistent. I think the problem that I have is when the court approaches a question and says, let's first ask if this is politically significant. I don't think that's appropriate judicial inquiry, and I don't think it's helpful. Again, I think that a non-delegation inquiry should be the correct inquiry. So I think the court should focus on that, because certainly each of these cases is important to the litigants in each case, right? So determining which litigants might raise more important questions than the other, I don't think is the correct inquiry. However, the one exception might be with the court with their discretion at the cert stage. If the court, borrowing from then Professor Scalia, he had a piece in EEI called a note on the benzene case. He essentially says the Supreme Court should kind of knock off a statute every now and then on non-delegation grounds to kind of keep Congress
on their toes.
Yeah, exactly. He was kind of a little tongue-in-cheek, but the court, if they wanted to consider the majorness of an issue, they can do that in their discretionary docket when determining which cases to take on through cert, and lower courts can do a similar thing when determining which cases to consider en banc.
Well, I take your point about the search stage. And so for those listeners who are not as focused on Supreme Court litigation, of course, the Supreme Court doesn't have to hear most of the cases that come before it. It has just what we call a discretionary docket. It can choose which cases it thinks are sufficiently important. And Congress has not, there's no actually clear legal authority mandating that the court necessarily take issues that check certain boxes or meet certain metrics. So the court could certainly, if it reached a statutory interpretation case where an agency regulation might be found to be unlawful, decide it's only going to take those ones that are particularly important, and in that way import a major questions doctrine, and so only take a close look at those statutes. I do want to point out, though, that I mean, because you have said now multiple times that what you think the more constitutional approach would be is to look first at the issue of non-delegation, and I just want to point out for listeners that may be right, and certainly an approach that scholars and you in particular have talked about, although it is a separate perhaps claim. One could, in other words, if one believes there's a robust non-delegation doctrine, believe that a statute is unconstitutional because because it either does in fact give away legislative power to an agency, or because of the danger that we don't want it to the Congress to be giving its legislative power away. We need to interpret the statute with that in mind and not interpret it to legitimately be giving that power away. However, there's a separate question that I think specifically the court was looking at in West Virginia versus EPA, which is regardless of whether it was constitutional or not, I don't even think the court acknowledges that anybody asked them to examine that. Is what the agency was doing within the text of the statute, whether it delegates broad authority or not. So correct me. So did I mischaracterize anything you were saying in that, Chad? I want to give you a chance to respond.
No, I think you're right. They are, the court has made clear they are distinct inquiries. I just think the better approach would say, one, use normal statutory tools interpretation. If the agency has the authority, then maybe check non-delegation and just skip the major questions entirely.
And Ellie, any final words for our listeners?
Yeah, I think what's going on here is really the canon of major questions is kind of smuggled in through the canon of constitutional avoidance. Now, it's true that in all major questions cases, you might not always have a non-delegation issue, but I think there is some significant overlap between the two. And my sense is two things probably are going on with major questions. One is, if we can decide a case on major questions grounds and say that Congress actually did not grant as capacious or broad an authority to the agency as the agency claims, usually, not always, but usually that means that the delegation problem can be cured through interpretation of the statute. And then the second thing is, it seems as though the major questions doctrine can act as a sort of triage for the non-delegation issues, where if we only really proceed to the delegation inquiry through the first asking the question, is this a major issue? Then you might be able to more clearly define the cases in which we're going to do delegation. Now, I don't know that that's legitimate. You know, the vesting clause of Article 1 doesn't say all legislative powers herein granted are vested in a Congress when the issue is really significant or it's of national importance. But at the same time, I think it's worthwhile to think through what the court is doing. I'll actually end on, there was a tweet that Kristen Hickman from Minnesota Law put out yesterday that I thought was great. And she said, take on West Virginia v. EPA, the Supreme Court is treating the major questions doctrine as a canon of construction, not as constitutional interpretation. In other words, Congress didn't give EPA the authority to adopt the regulations at issue. It's not that Congress can't give the EPA that authority. It just didn't in this statute.
All right. Well, thank you for those last words. Thank you both for joining us. This was fascinating, a momentous or a significant end to a momentous term. And hopefully you all will join us again on Pulse of the Court here with the Gray Center for the study of the administrative state. Have a great 4th of July weekend, everybody.
Thank you.